As a criminal defense attorney who does a lot of work in the area of DUI and driving-related crimes, I get a lot of questions about California Penal Code 191.5b, or 191.5b PC for short. This is the section that defines the crime of vehicular manslaughter while intoxicated. Now, there are two closely related crimes. There is gross vehicular manslaughter while intoxicated, which is more serious, and then there is vehicular manslaughter while intoxicated, which is less serious but still a serious crime. The difference is that gross vehicular manslaughter requires gross negligence or extremely reckless driving, such as weaving in and out of traffic or blowing through stop signs and red lights. Ordinary vehicular manslaughter does not necessarily require reckless driving. It only requires that you violated some traffic law or drove with ordinary negligence. Today, I'm going to talk about ordinary vehicular manslaughter while intoxicated under 191.5b PC. In order to prove this charge, the prosecutor has to show three things. First, that you were driving under the influence of alcohol and/or drugs. Secondly, that you broke some traffic law in a negligent manner. That could be speeding, following too closely, not having your headlights on at night. And third, that in so doing you caused the death of another person. Usually this means causing a collision with another vehicle, or hitting a biker or a pedestrian, or crashing your vehicle to where one of your own passengers is killed. 191.5b PC is what we call a wobbler. That means it can be charged as either a misdemeanor or a felony. As a misdemeanor, it carries a sentence of up to 1 year in jail. As a felony, it carries up to 4 years in jail or prison. Keep in mind that if prosecutors elect to charge the more serious crime of gross vehicular manslaughter while intoxicated, that carries up to 10 years in prison. And in some extreme cases, the DA can even charge second-degree murder, which carries life in prison. But as serious as vehicular manslaughter is, and as tragic as it is any time a person is killed, we find that oftentimes the police and the prosecutor rush to judgment and bring a case on someone where they really should not. You may have had a couple of drinks but may not have been intoxicated as the law defines it. Or it could be a situation where you were not really at fault for the accident. The CHP may have done a sloppy investigation and rushed to point the finger at you just because you were the one drinking. Anytime we represent a client in a vehicular manslaughter charge, the first thing we do is have our own accident reconstruction expert do an independent analysis of the accident. Often we find that it was really the other parties who caused the accident, or there was some independent cause, such as road debris, such that the accident could not have been avoided. If we can show that you were not intoxicated, or that you were not at fault for the accident, then there's a good chance we can get the charges reduced or dismissed.